Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, last week, as you know, we had a huge victory out of the Fifth Circuit Court of Appeals in a case called Cargill v. Garland. It dealt with bump stocks, but I, at the time, having had a chance to get through the case a couple times, said, hey, listen, not only is this an amazing ruling, but it has some very far-reaching and positive implications for us moving ahead on this battlefront that we have on firearms with attached stabilizing braces. Well, I've had a chance to geek out a little bit more on this case, and I actually think there's a lot more to unpack, and I think most of it is actually really, really good. So today I'm going to give you a theory of mine, and hopefully you'll agree. So let's spend a few minutes and talk about how the bump stock ruling undermines all of Operation Reticent Recall. Okay, so the issue we're talking about again today is the case of Cargill v. Garland, a case that just came out in the last few days from the Fifth Circuit Court of Appeals, basically overruling ATF's ban on bump stocks that took place after the horrible shooting in Las Vegas. It was during the Trump presidential administration. There were two pieces of legislation that were kicking around in Congress that could have banned bump stocks, but ATF decided they needed to cut to the front of the line. And let us also remember in that ATF had previously issued letters, multiple letters, saying, hey, bump stocks do not constitute machine guns. We've looked at the law. We take a look at the technology. They do not constitute machine guns. Then with a little bit of political pressure from a president who wanted to ban them after the shooting, they immediately just did a 180, turned around, and suddenly they were banned. Now, that led to all sorts of problems, some of which were discussed in Cargill v. Garland. Other ones have been discussed in other cases dealing with the unconstitutional takings. But now that I've had a chance to geek out and go through this opinion a little bit more and take a look at the analogy of what occurred here, take a look at the rule of law, and most importantly, take a look at the comparisons what the ATF did with bump stocks and what they have done with forced reset triggers. Sound familiar? That's right. I believe that this case absolutely guts all of Operation Reticent Recall. Now, what is Operation Reticent Recall? Well, I was hoping I would never, ever have to do a video on this again, but this was ATF's sudden about face as it related to forced reset triggers, wide open triggers, and then solvent traps. We're going to keep the solvent traps out of it, but there had been previous advisory opinions, previous open letters from the FFL as it related to the forced reset and wide open triggers that these do not constitute machine guns. So a lot of you lawful and responsible gun owners went out there, purchased these items only later to find out that ATF was doing an about face, and many of you even had to deal with ATF over the late summer and early fall of last year. I assisted some of you with that as ATF went around the country in their scavenger hunt, better known as Operation Reticent Recall. Now, when we take a look at what ATF did with these force reset triggers, and we compare that to what they did with these bump stocks, I'm telling you folks that this case right here absolutely guts everything that Operation Reticent Recall was based upon. Now, let us remember that while Congress could have passed legislation that banned bump stocks, and then we could have argued about the constitutionality of that legislation, just like Congress could theoretically ban forced reset triggers, and then we can argue about the constitutionality of that. That's not what occurred here. No. ATF created rules that reinterpreted laws and were allowed to basically implement new criminal laws without any act of Congress. Now, you know who was really concerned about it at the time? It was Senator Dianne Feinstein. That's right. I know all of you just did a double take. Senator Dianne Feinstein. Yeah, that's right. Not one of the most pro-Second Amendment senators on the planet. In fact, probably one of the most anti-Second Amendment politicians in modern American history. However, when ATF decided to ban bump stocks, this is what Dianne Feinstein had to say about it. Until today, the ATF has consistently stated that bump stocks could not be banned through regulation because they do not fall under the legal definition of machine gun. Now the department has done an about face claiming that bump stocks do fall under the legal definition of machine gun and it can be banned through regulations. The fact that ATF said as recently as April 2017 that it lacks this authority gives the gun lobby and its allies even more reason to file a lawsuit to block the regulations. And so, listen, we may disagree with Dianne Feinstein on just about everything she stands for, but even she recognizes what ATF is doing. And she wasn't done there, because she went on to further state, unbelievably, the regulation hinges on a dubious analysis claiming that bumping the trigger is not the same as pulling it. The gun lobby and manufacturers will have a field day with this reasoning. What's more, the regulation does not ban all devices that accelerate a semi-automatic weapon's rate of fire to that of a machine gun. Both Justice Department and ATF lawyers know that legislation is the only way to ban bump stocks. The law has not changed since 1986, and it must be amended to cover bump stocks and other dangerous devices like trigger cranks. So even Dianne Feinstein realized exactly what was going on. Now, when we dive into the holdings of Cargill v. Garland, and we see what the court was hanging its hat on, one of the things they said is, listen, when you look at the technical definition and just apply a plain English meaning to what a definition is, it all comes down to this whole bit about a single function of the trigger. Now, let us remember that the statutory definition for machine gun under applicable federal law is as follows. The term machine gun means any weapon which shoots, is designed to shoot, or can be readily restored to shoot automatically more than one shot without manual reloading by a single function of the trigger. And you see, it is that last few words there, by a single function of the trigger, that caught the court up, because what the government is arguing here is, yes, we understand that the trigger goes through multiple functions, but it's a single function by the shooter, you see, and that's what we meant. And the court was really, really wise when they said, well, wait a second. When we take a look at the same federal statute, and it has definitions of rifle and shotgun, in there, you actually use the terms by a single pull of the trigger, thus talking about what the shooter themselves is doing to the firearm or to manipulate the firearm. However, when we look at the definition of machine gun, what's happening here is you're talking about a function of the trigger regardless of what the user is doing to it. Does that sound familiar? It sounds exactly familiar, because that's exactly what forced reset triggers do. They take the exact same technology that was in bump stocks, and they place that technology into the trigger using the force of the recoil to reset the trigger. The trigger has to function each and every time, though, for a new round to be expelled from the firearm. Listen, the government tried this argument, and this is how the Cargill court responded to that. The government contends that the single function of the trigger means a single pull of the trigger and analogous movements. That is, according to the government, function means pull. But that argument fails on its face, because a shooter still pulls the trigger of a semi-automatic weapon equipped with a non-mechanical bump stock each time he or she fires a bullet. Without a bump stock, the trigger activates because the shooter flexes his or her finger. With a bump stock, the trigger activates because the recoil of the previous shot re-engages the trigger, and the shooter's maintained force on the gun's forebody bumps the trigger against the shooter's finger. This is a distinction without a difference. The end result in both cases is that the trigger is pulled. And that is exactly, and I do mean exactly, what's going on with forced reset triggers. Now, the court went on to further state the statute uses single function of the trigger, not single function of the shooter's trigger finger. And listen, this is a really simple, plain English interpretation, which is exactly how we're supposed to interpret statutes. We start with a plain English interpretation. If that answers the question, we're done. We don't need to take a look at anything else. And this is how the court put it. The statutory definition of machine gun utilizes a grammatical construction that ties the definition to the movement of the trigger itself and not the movement of a trigger finger. And again, one of the things that the court was really caught up on is when you take a look at the definition of rifle, right? It's a firearm with a rifle bore, length of over 26 inches, barrel longer than 16 inches, which is designed to be fired from the shoulder that expels a round for each pull of the trigger. So it defines on what the shooter has to do to manipulate the firearm. The definition for shotgun is the same way. The definition is based in part on the action of the shooter themselves. But when we get to the definition of machine gun, and this is how the federal government decided to draft their legislation, it does not have anything to do with what the shooter has to do or does not have to do. It has to do what's happening internally in the fire control group, and that trigger is being pulled and activated for each round that is being fired. The court specifically stated, to summarize, the definition of machine gun must turn on the action or function of the trigger because no other action is mentioned or implied. This conclusion is only strengthened by the fact that other definitions within the same statutory provision explicitly turn on the action of a shooter, showing that Congress knew how to write a definition that proceeds from a shooter's perspective rather than a mechanical one if it had wanted to. The notion that the definition turns on the action of an unnamed shooter is inconsistent with both the grammatical and statutory context. And so if that is the rule of law, if that is how our appellate courts are going to define what a machine gun is and shockingly use the plain language in the statute itself and apply the plain English definition to every word in that statute, a shocking concept, I know. But if that is the standard, how then can ATF do the about face that they did on the forced reset triggers and the wide open triggers and the binary triggers and everything else that they put on their little hit list, better known as Operation Reticent Recall? It is my opinion that this Cargill case is a wonderful case on many levels. Obviously, it guts ATF's gross overregulation of bump stocks. It rules that that was unlawful. Secondly, it provides a roadmap for why ATF cannot overregulate firearms with attached stabilizing braces, their Form 4999, their Form 1 amnesty registration, all of that stuff that's coming up. It is absolutely positively overruled here by Cargill. And finally, and perhaps most importantly, for the purposes of today's discussion, this case absolutely guts everything that Operation Reticent Recall stood upon. Listen, you may have more questions about this case or anything else related to your Second Amendment rights, and you guys know the drill. If you want to contact us, you can always get a hold of us at WashingtonGunLaw.com, or you can call us directly at 425-765-0487. In the meantime, let's remember, part of being the lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.